So this is Justyn Kasierski. He's our guest speaker today, managing partner at Hutch Law. Let's give him a round of applause.
Thanks. I appreciate it. Yeah, no need for that.
And you could also hold that, or you can clip it onto your...
Okay, cool. Yeah, so just to orient to who's in the room, how many of y'all have actually formed a company so far? All right. So most have, some have not. Those of you that have formed companies, you've already allocated your founder equity amongst the team? No one? Okay. So we've got some founder allocation questions potentially. How about having folks that aren't founders work for your company? All right. Anyone have that going on but don't have any legal framework for it?
We're about to start doing that.
About to start doing it? All right, cool. In terms of the IP stuff, I know we've got a few software startups. Anyone working on hard tech stuff or anything like that? Yeah. What kind of hard tech?
Well, I don't know where you're going with tech, but like a physical product, I guess.
Yeah, I'm thinking about the difference between registered IP, like patents and stuff like that, versus other types of IP protection. So I don't know if you've had a chance to talk about that with anyone. All right, we'll cover some of that too. Yeah, so I've got a prezzo, but it might make more sense to just kind of dive into some of these topics and see. The presentation that I brought with me is a little bit of an off the shelf. It's about, founder allocation of equity, founder issues, things with initial fundraising that come up with early stage investors, how to manage a cap table, how to issue equity to team members and all of that. So we can cover any or all of that if you want, based upon where your companies are at. Although it seems like you got a group that's in some different places here, which is fine. First things first, I'm just gonna cover off like Startup Legal 101, which I actually thought was kind of the topic, right?
The mic.
Yeah, sure. Okay. There we go. Better?
Yep.
All right, cool. All right, so when you form a legal entity, you're generally going to make two big decisions, right? You're going to make a decision about the choice of entity that you're going to use, and you're going to make a decision about where you're going to form that entity. Legal entities are governed by state law, okay? So you can choose to form an entity here in the state of Florida. You can choose to form an entity in the state of Delaware. You can choose where you want to have your entity created. Generally speaking, folks tend to pick the state in which they're residing as the state of formation, so Florida for folks here in Florida. But for folks that are seeking venture capital and want to become what's known as an emerging growth company, whether you start there, you're eventually going to end being a Delaware corporation. And that's primarily because the investors that are going to invest in your company, they don't want to get to know all 49 state laws. They know Delaware law. That's the entity that they want to invest into. So you might form as a Florida company, but you might not be surprised to turn into a Delaware company eventually. Some of the startups that we work with, they just go ahead and start right away in Delaware. All right, so choice of entity, you've got all the states available. By the way, just raise your hands if you've got questions as I'm going, because I'm going to move kind of quick. Okay. Yeah.
I used to be like watching and I saw like some companies like remote.
Yeah.
How does that work?
How does it work to be a Delaware corporation when you're not in Delaware?
Like they were saying that they would be like remote. I don't know if that has to do with like the Delaware.
I'm not sure if it has to do with the Delaware thing, but where I thought you were going is you don't need to be physically present in the state in which you form your company. You can hire companies that are known as agents, registered agents. They act as your mailbox, if you will, on the ground in the state. And so even if you grow and build your company here in Gainesville and become a Delaware corporation, you can do all of that here and you'll have an agent in Delaware. I'm not sure that's the remote thing that you're talking about though. No worries. Yeah.
So if we were based in Florida, we could make it as a Delaware company. You're just saying we need to have some sort of mailbox or whatever in there in Delaware to be able to handle mail.
Yeah, dude, it's a whole industry around this registered agent thing. So if you don't know, Delaware is the place to be a corporation, okay? And because it's the place, it costs money to do business in Delaware, which is why a lot of startups choose to do things in like Florida or Massachusetts or some other state where it's a lot less expensive. But when you become a real company, respectfully, you end up in Delaware. And then you end up hiring these registered agents. And I said mailbox, that's really not a fair. They basically act as your representatives to the state of Delaware. So if the state of Delaware needs to reach you for some reason, they get in touch through your agent. Okay? So choice of state, kind of easy. Choice of entity, not always as easy. Generally speaking, you're going to fall into one of two camps out of the gate. You're either going to be an LLC or you're going to be a corporation, okay? Kind of like no matter where you start, you're going to end up in Delaware for the choice of state. With the choice of entity, it almost doesn't matter what you choose to start. If you go and raise venture money, you're going to become a corporation. Go ahead.
Yeah, for like Delaware, like C Corp or something, say for example.
Yeah.
Like I've always heard that it's the best just for like tax reasons, and I've never heard anything beyond that. Is that?
Depends. That's a good question. So the Delaware C Corp, which he just mentioned, right? That is the gold standard for venture-backed companies. And it's not like only venture-backed companies, but like that's what you will eventually turn into when you raise real venture money, is a Delaware C corporation. That C, the letter C, that's a tax classification, which means that your corporation is a taxpayer with the IRS, okay? When you're an LLC, the LLC is not a taxpayer. The LLC passes through its profits and losses to the owners of the LLC, and you pay taxes based on that. So sometimes people choose to be an LLC out of the gate because startups lose money. And if my startup's going to lose money, I can take those losses as a pass-through and use them to offset income that I have from other areas. So early on, an LLC may make a lot of sense for me if I know my startup's going to lose money. Some people don't care as much about that part of it. They're just going to bootstrap. There's not going to be a lot of losses. And so they go ahead and start as a C corporation out of the gate. It is important to understand, aside from taxes, and I'm not a tax attorney, so that's about the depth of what I can tell you comfortably on the differences. But the other things to understand about the difference between an LLC and a C Corp in terms of operating your company is if you're going to be using incentive equity, option awards, and things like that for your team members, those are a whole heck of a lot easier in a C corporation than they are in an LLC. An LLC does have a version of that you can use. You can actually issue options, or you can issue what are known as profits interests. But it's a bit more complicated, and it actually entitles the people that are getting that equity to a bit more in the way of legal rights than they would have as an option holder in a corporation. So one of the times in which a lot of our startup companies, ahead of getting outside funding, may end up moving from being an LLC to a corporation is when they want to start issuing incentive equity. They say, fine, we're going to move over, we'll adopt an option plan and start issuing options to our consultants and advisors. Do you have a question? All set. You did. Yeah.
So you're saying that most LLCs eventually turn into C corps.
Yeah.
They grow. Is it just easier to be start as a C corp, or is it a nightmare to take an LLC into a C corp?
It's not a nightmare to convert. No, the legal conversion process actually. So you're not going to be pissed with your lawyers at the cost, but you may be pissed at your accountants because it is a pain in the ass, or it can be a pain in the ass on the accounting side. You need to do a final set of K-1s. You need to basically wrap up all of the accounting of the LLC in order to issue out that final sort of profit and loss to the owners. And if you do that on a day that's not the end of the year or a quarter end, it's just a lot of work, potentially, for your bookkeeper. If you're like a wicked small startup with really simple accounting, it may not be all that expensive. But generally speaking, it's not. So when you do it in connection with a financing transaction, you won't feel it. The cost of it will just be part of the overall financing and it'll get done. When you do it as a standalone, like you want to start issuing incentive equity or something, probably budget about $5,000 for both legal and accounting to make the conversion. So is it worth it? I think it comes down to that tax decision. Do you feel strongly about having the pass-through losses? Because you really don't want the pass-through gains, right? Then you're paying taxes on income that you may not have gotten any cash for. But if the losses are worth it, then And that's why a lot of companies that do it. Sometimes they have a rich aunt who's investing into their startup, and the aunt wants the pass-through losses, right? That kind of thing. So may not just be a founder decision. All right, so that was like the fastest I've ever done. Choice of entity, choice of state, things like that. Quickly on founder allocation, all right? And so from here on, for the most part, my default is going to be talking about a Delaware C corporation. So if you've got questions specific to an LLC, let me know, all right? Founder allocation. Founder allocation, it's funny, we get folks that reach out regularly, right? We're starting a company. A good number of them show up and they say, we've spent a lot of time together working on this, and we've negotiated, and here's the founder allocation. A surprising number of them show up on Zoom or in the conference room and say, we thought you were going to help us figure out how much of this company we each own, right? Which we're happy to do, but ultimately it's an allocation among the owners of the firm in terms of, how much of the company out of the gate will they have. Now, that matters for a couple of reasons. Founders as stockholders, that is the most important role in a company, right? The stockholders control the company by majority vote. The stockholders also elect the board of directors. The board of directors is important because the board elects the officers. They decide who's going to be the CEO, who's going to be the VP marketing, all of that stuff. And of course, the officers are important because they run the company on a day-to-day basis. So as founders, out of the gate, you may have 3 roles, right? You may be stockholder, board member, and executive of the company. That would not be unusual for the founders. So we're talking about this upper level, the stockholder level, and how do you allocate ownership there? Sometimes folks think about their allocation of ownership in terms of how much time they've put in. They also think about who's contributing what in terms of either hard IP, soft IP, network connections, those types of things. And then the third factor that they think about is the potential for contribution going forward, right? So for example, your classic, if you will, university or UF spin-out company, if you're working with a professor, that professor may not be contributing that much to your company going forward, right? Their contribution may all be encapsulated in the IP that you're licensing from the university, and they may have kind of a smaller role going forward than they had up to the point in time in which you start the company. So those are the different factors, generally speaking, that folks think about when they're looking at how to allocate founder ownership. I'll pause there. Any questions on allocation of ownership among founders? Everyone's cool? All easy conversations, right? Sometimes it's like this passive-aggressive sort of, majority is key. Listen, as your lawyer, like that's the thing you want to keep an eye on, right? If one person doesn't hold a majority, well then who needs to vote together to get to a majority, and how does that stuff sort of work? So keep that in mind, that 50% voting threshold. Yeah.
When you say ownership, are you speaking in terms of you create a certain amount of stocks? In
Great
the company
question.
And then
Yep.
divide them?
Yep.
Or are you saying it's a 60-40, 55?
Great question, yeah. I'm referring to it as percentages, but from a practical standpoint, your corporation will issue shares to the founders, and then the total number of shares issued, that denominator is what I'm basing my percentages off of. So if we form a company and it's got 10 million shares, and we issue those 10 million to the founders, then we can figure out, okay, who owns 51% and all of that based on that. As this is important, because some people think, oh, and then when I bring in new people to my company, I'll just give them some of my shares. That's not how it works. Your company continues to issue shares to the people that join as you grow. So it'll issue shares to new employees, it'll issue shares to investors, so the denominator just keeps growing. That's the concept of a dilution, right? So you get 5 million shares out of the gate. When it's 10 million shares, awesome, 50%. When it's 50 million shares, a little less awesome. However, if that 50 million share company is worth more than 10x the startup value, you're doing well, right? So dilution, generally speaking, well, sometimes people understandably get concerned about dilution. My ownership's going down, my ownership's going down. You need to think about dilution from a value standpoint, right? There's this classic, would you rather have half of a grape or a slice of a watermelon, right? Even though a slice is a much smaller percentage of that watermelon, it is much more meaningful than half of a grape. So what you care about alongside your ownership percentage is what the overall value of your company is and what is your percentage worth. Yeah.
Is there a way to delegate the value of the company shares versus the voting of the company shares? So if we wanted to raise capital, but we wanted to keep the right to make decisions?
Yeah. So you can have voting and non-voting stock where, in our 10 million share example, you could set up 5 million voting shares and 5 million non-voting shares. And the non-voting shares just get the economics, and the voting get to vote on things like board members and stuff like that. It's important when you think about that to think about, and probably chat with an attorney about, well, what do stockholders really control, right? Because again, for the most part, your board is where a lot of the action happens in terms of the direction of the company, the hiring and firing of the team, approval of budgets, that kind of stuff. But we do see non-voting stock from time to time in companies. It's just not the most common thing. All right. So we've allocated shares, we've got a cool team, everyone's happy. One thing that you probably have heard of, and if not, you need to be aware of and think about for your startup and your founder shares is vesting. Is anyone not familiar with the concept of vesting? All right, cool. Vesting is this concept of my company just issued me founder shares. The company now has the right to buy back those shares if I leave the company, right? Vesting is what ties you to the company for some period of time. This is super important, okay? Without vesting, the day after we form the company and the day after we issue our 10 million shares, anyone could leave and walk away with his or her ownership. And they just have it. It's a property right under law. So vesting is a contractual agreement that each founder signs where they say, I'm agreeing to work for the company for, typically it's 4 years, right? And if I leave before 4 years is up, the company can buy back a portion of my shares. And typically that buyback right kind of goes on a sliding scale over the 4 years. So if you leave after 2 years, 50%, et cetera. It's not unusual for founders to sometimes divide their founder shares into a portion of shares that are not subject to vesting, which kind of represents the time they've already worked on the business before startup, and then have the rest subject to vesting. But that doesn't have to be the case. You can have it all subject to vesting if you want. We hear all sorts of stories from founders about why they don't need vesting, right? They're best friends. They're in each other's weddings. They've known each other, all this other stuff. That's all fine and good. We still strongly recommend vesting for a couple of reasons. One, unexpected shit happens all the time, right? Family members get sick, people get injured, life plans change, all of that. A vesting agreement is kind of a starting point for a hard conversation, right? Ideally, you'll sign your vesting agreement and never look at it. But sometimes you do have to look at it and say, remember when we chatted about 4-year commitment and I understand what happened with your mom and I'm sorry, but that's the legal jumping off point for that conversation. The second big reason to have vesting is because if you don't put vesting on yourselves, your investors will. These folks or some other folks who write early stage checks will come into your company, and they're sure as hell not going to write a check into your company and then let you bounce the next day after the check is written, right? They're going to want vesting. So negotiating vesting amongst yourselves may result in more founder favorable vesting than negotiating it opposite early stage investors. All right, any questions on vesting? Cool, we are cranking. Go ahead.
Yeah, Do you typically see like a 1-year cliff and then the 4?
Good question. Yeah. So you're read up on stuff. So the 4-year vest is a standard vesting period for employees, people that you hire. The cliff usually applies there. For founders, it's like you're in the club, right? If you're part of the founding team, we're not going to make you spend the year, unless you're like brand new to the founding team on the eve of forming the company or something. But for most founding teams, there's no cliff. Yeah. Yeah.
How much notification do you have to give other founders before just cutting them before the vesting schedule? Do you have to give them multiple warnings? Do you have to give them written email? Or can you just cut them?
So let's talk about how that happens, right? I mean, this is one of those majority vote situations typically. So from a legal standpoint, let's say we want to let one of the founders go. The board would be the group that's in charge of letting one of the founders go. So if we've got let's assume for an easy hypothetical, 3 founders, all stockholders, 1/3 ownership each, all 3 are on the board, all 3 work for the company, 2 of the 3 say, she's no good, we got to move on. Legally speaking, what happens there is the stockholders remove that person from the board, and then the board terminates that person as a contractor or employee of the company, and that all happens at the same time. How much notice do you need to give? Technically, not any. How much should you give? A lot, right? Like, it's a founding team. You should really be trying to work with this, but from a legal standpoint, you're not entitled to continue to work for any business, regardless of whether you're a founder or not, okay? The board has the right to remove officers. The stockholders have the right to remove board members. So it would be good to give notice. The question that I have with the notice is like, to what end, right? Is it notice because you want them to change behavior? What are you looking for? Usually there is a lot of communication and no one's surprised about this stuff, but sometimes that does happen too. And sometimes it's just a complete misunderstanding and misalignment among the founders. But legally, you don't need to give any. Okay. But we're not firing any founder members in this group. Everyone's cool. They're all fine. It does happen. I mean, we've got a company here in the hub that we work with, and no vesting, 1/3 each. There's one dude who's pulling more than his fair share. There's one professor involved who's kind of okay. And then there's the 3rd guy who just ghosted him and is over in China. And they call and they're like, how do we get this 1/3 of our company back? It's like, well, I got some bad news. You know, really the only way to get that back is to get that person to agree to give it back. It's their property. It's like going and trying to take their laptop or their car. How do you get it from them? Only if they sign it over to you. So those things do happen. All right. I'm going to touch quickly on bringing other people into the company, okay, because this relates a little bit to your question and also to the equity question. When you bring people into your company, and you're going to sign these agreements as founders as well, you're going to have one offer letter, simple piece of paper that kind of lays out the business terms, right? I'm paying you hourly, I'm giving you some equity, I'm giving you a salary, whatever that is. You're going to have that. The key document from a legal standpoint is what's known as a proprietary information and inventions assignment agreement. And everyone that works for your company should ideally sign a version of this. And it does up to 4 things, 2 of which are fundamental. The first is they agree that everything they learn about your company, know about your company, they keep it confidential. All right? The second is anything that they work on, develop, all of that related to your company, the company owns. This is super important for startups. State law generally says for employees, it's implied that the companies own what the employees work on. But that does not extend to consultants and advisors. And most startups are not hiring employees, right? They can't afford employees. They're hiring consultants and advisors. So making sure that those folks sign up an IP assignment provision is super important. Go ahead.
I'm sorry, you call this a
Proprietary, let's call it a business protection agreement. Yeah, easy. That's my preferred term. Yeah, there's an industry term known as a PIIA, Proprietary Information and Invention Assignment Agreement. I prefer BPA because it's less of a mouthful, but it does the same thing. All right, so again, 4 parts: confidentiality, IP assignment. The other 2 are not, well, how do I put this? The other 2 are things that you would really like to have, but are sometimes harder to get, particularly with early stage advisors and consultants: a non-solicitation and a non-compete, right? Ideally, you'd like people to agree that if they leave your company, they're not going to come back and start poaching your team members, poaching your customers, things like that. That's the non-solicit. The non-compete, as the name implies, is you won't leave my company and go out and start directly competing with my company. Now, for a lot of folks that are working with your very sketchy, very risky early stage companies, like, they're not going to sign up to that because you may be gone, right? So you just need to kind of know where you can get your non-compete, maybe try for it, but don't worry too much about it if you can't, particularly if the person's bringing a lot of value. But those first 2 things should be no-brainers, and then as you grow, your BPA should ideally have all 4 parts in it, and all your employees should be signing it. The version that y'all sign as founders should have all 4 parts in it, which is important to keep in mind back to our, throwing someone off the island example. If you're the one thrown off the island, you may be subject to a non-compete that will prohibit you from working in the same space as the company for a year after you're let go. All right. So you don't have any cash, or you're low on cash, and you're bringing people in. How do you compensate them? Because it's important to compensate them. This is incentive equity, right? This is the idea of issuing options or restricted shares to get people to do work for you, get them to bet on your company. They should have vesting on those shares. It should be tied to the work that they're doing. For the most part, time-based vesting makes sense. And remember I said that 4 years is the standard? That's true for employees. At this super early stage, it's usually what you can negotiate for vesting, because no one's really planning to hang around for 4 years from the people that you're working with now, right? So it may be like a 1-year vest or something like that. We see a lot of startups over-dilute themselves at this stage by giving away too much equity to these early stage consultants and advisors. So just be mindful of how much equity you're giving away and what you're promising to folks. And also be mindful of making sure you're getting something back for that equity. I'm trying to think if there's much else on equity awards. Yeah.
When you were first talking to startups, do usually you guys see them like from their inception and then on? So I was going to ask about like option pool sizes, or like 5 different financing ones.
Yeah, so that's a great question. And let me kind of double click on that for the group. So when you want to start issuing equity in your startup company to, we'll call them service providers, people that work for your company, you need to jump through a couple of small legal hoops in order to do that, in order to comply with tax and securities laws. What you need to do is you need to set aside or reserve a certain number of shares, and you call that your incentive equity pool, and then your board makes awards out of that pool to the folks that you're going to hire. The stockholders and the board are in charge of determining how much that is. In my experience, the size of the pool for a pure startup depends a little bit on the size and capacity of the founding team. A solo founder may need a larger pool because she needs to hire more people than a startup team of 7 who may not need to hire people right away, right? Generally speaking, when you get to your first round of institutional venture financing, they're going to be expecting you to have 15, 20% of your company set aside in a pool for team members. And part of the reason they're expecting that is because they don't want to be diluted after they invest by having to put more shares into the pool. So, and this is kind of an advanced thing, right? But when you get to the point of negotiating for venture investment, this is a big part of the negotiation. how much goes into the pool. Typically speaking, our guidance is come up with a hiring plan for the next 2 years, plan out or budget out how much equity you need for the people you think you're going to hire as you're spending the VC's money to hire people, and then use that as the starting point for how much equity you need in the pool. All right. Team members, equity, founders, yeah?
Earlier, you said to ensure that the people you hire for advising, consulting, et cetera,
Yeah,
that they give you something in return, right?
right.
Whenever you have, like, we're doing software development, if we're hiring someone to do a specific task,
Yes,
I'm assuming that we put that into the agreement, like what that task is.
100%.
What is the best way to get advice on how to write those agreements / ensure that the person you're
Yeah.
getting work from /
Yeah.
you fulfill what you're doing?
It's a good question. So generally speaking, your service providers are going to fall into 3 categories: employees, consultants, and advisors. Employees are kind of easy in the sense that there's a job description, and you're usually a bigger company when you get to the point of employees. Advisors are kind of easy because advisors are folks like these guys here, right? They're smart people, known, and really what you want is you want them on your cap table so that when you pick up the phone and call, they'll answer and give you advice. That's what advisors do, as the name implies. Consultants can be sketch. All right, so consultants, you really need to lay out in the agreement what it is, and I don't mean consultants are sketchy, I'm just saying from a legal standpoint, like your agreement matters a lot in terms of what's in there. And so you really do want to ideally work with an attorney to get a good form of consulting agreement. The one that we use is like 5 pages of boilerplate, and then all of the action is in the exhibit at the back. And the exhibit at the back has 2 big sections: what you're going to do and what you're going to get paid. And sometimes the what you're going to do is like 1 bullet point. You will perform fractional CFO functions for our company. Other times it's you will deliver this module, this, you will do all of this. It can be simple, it can be complex, but the reason I like our form, and I'm partial, but we can steer our founders to just focus on Exhibit A. We'll help you with the language, but you fill out Exhibit A, we'll look at it when you're done, and then we'll know it's good, right? But that's the way you should be thinking about making sure you're getting something back, is do you have a signed legal agreement that explicitly lays out, here's what you will do, and are you comfortable with it? Yeah.
I know you spoke on kind of, differences in people's, Exhibit A's and what they're supposed to do and what they're executing on.
Yeah.
When you make the argument to do less and kind of keep it vague versus when you make the argument that you need to pull it out versus what can you execute?
That's a really good question. Personally, I think it comes down to the consultant and the strength of the relationship or the strength of the background checking you've done, right? Like if this is a known commodity, referred from other founders that all of that, I think you can get more comfortable. I will say though, when it comes to folks that are specifically developing pieces of IP, and we see this more in software, obviously, is these folks are typically not just doing one thing, right? They're doing 17 things. And so you would ideally like to have a piece of paper, just to avoid any fights in the future, a piece of paper that says exactly what they're going to develop so that they can't come back later and say, well, no, that wasn't part of my gig, right? So the looser it is, it cuts in both directions, right? But the more specific you are, the easier it is for them to come back and say, well, that wasn't part of what you were paying me for. Where if it's looser, you may be able to say, yeah, but it falls under this umbrella, right? As an attorney, I like more specificity. I like that stuff. If you didn't cover it off in the first draft and now you want them to do something that's not in there, maybe you got to give them a little extra in order to get it. Yeah. All right, so we've got team members, we're issuing equity, we're humming along. We're talking about IP, right, which was a question. Yeah, go for it. Yeah.
So I ask this question a lot, but people never give me a straight answer.
I'm great at not giving straight answers. Not giving straight answers is how I made a career. So, no, I'm just joking. Yeah. Yeah, no, actually, I tend to be a real straight shooter on this stuff, seriously, so, go ahead.
Hypothetically, let's say I'm a startup here and I'm working in a professor's lab,
Mhm.
right, and I'm developing certain types of IP in that lab.
Mhm.
How would you suggest me navigating that IP space under like the college and everything like that?
Are you an undergrad?
Yes.
Yeah, so you've got more flexibility than grad students and professors and things like that. The question, and I don't know how you're developing, is this a sponsored research agreement?
No.
It's not. This is just de novo research that's being led by a professor.
Well, so I came to the professor and
Yep.
I asked him if he could help me with this. He said yes.
Yep.
You can use my facilities.
Yep.
Do whatever you need.
Yeah.
Things like that.
Okay. And you're the only one developing it, though?
I have advisors who help me.
Okay. Any of them university employees or grad students?
Yes, they work under the.
Yeah. So I'm not sure how generally applicable this is to the group, but at a high level, if you're working for the university owns whatever it is you think of, develop, et cetera. Sometimes there's actually a company alongside the university, a sponsored research agreement, right? Like BASF comes in and they write a check to a certain lab because they want something specific developed in the lab. Then it goes from the university to BASF. Undergrads who do something completely on their own and do not have involvement from anyone else in the university, you're going to own that, okay? Where your situation gets a bit gray is you own what it is you've developed, but your company may not have the right to use what other folks have developed without getting it licensed to them from the university, because the university's rights would sort of capture whatever it is that they've worked on. So that's, and I don't know how to divide that up. You need to think about what that is that they've worked on. The other area that, and you mentioned this, the other area that sometimes comes up is the use of the lab space, and that's why I asked about the sponsored research agreement. My suggestion would be to talk to the professor about it and see what he or she thinks about the use of the space and how, if at all, that may impact any university rights. But we see stuff come out of universities regularly from undergrads who are sort of tinkering around in a lab or something like that, and without universities kind of claiming rights on what's developed. But again, sort of pure student-led, student-only type of IP development. I guess just to back up, right? You develop something, I develop something, you own your thing, I own my thing. This is why we form a company, so that we put our chocolate and peanut butter together to form something awesome, right? But if I'm working for the university, I may want to bring my chocolate and do it, but I can't. We got to get the university to agree to do it. Is that helpful? Yeah. I didn't give you a great straight answer, but hopefully it's a little bit. Yeah. How about this? You're in a better position than a lot of folks in terms of most of them, the university is going to immediately have rights because they're employees of the university. Yeah.
Building on the conversation with the IP space,
Yeah.
how do you know what is patentable and what is that process like, especially for software?
Yeah. All right. So good question and fantastic opportunity for me to say I'm not an IP attorney. So I'm going to tell you a corporate attorney's perspective on IP, and I'm really going to punt on the patent stuff because they're the smartest attorneys there are, patent attorneys. So generally speaking, there's 4 types of intellectual property protection available to you: trade secrets, trademarks, patents, and copyrights, okay? Trade secrets are things like the formula for Coca-Cola. You develop it, you write it down, you never share it with anyone. That's IP. That's also the easiest type of IP protection to lose, because the moment you share it with someone publicly, it's no longer protected under law. All right. Copyrights. Copyrights are the things that y'all are familiar with, copywriting music lyrics, books, stuff like that. It's stuff that's reduced to written form and is originally developed, and you can file for copyright protection on something that's copyrighted, like your song or your novel or something along those lines. Yeah.
Logos.
That's trademarks. So trademarks are things like logos, branding, that type of stuff. Yeah.
Would code be considered copyright straight down?
Yeah, it could be. We-
copyright certain sections of code?
Yeah, we've seen that. The trick with it is the publication of it, and generally speaking, our software company clients don't find that the process of jumping through the hoops to get copyright adds all that much more protection because they're constantly tweaking their code, right? They're constantly going back. So we could use copyright. So technically, just to jump ahead a little bit and then come back to trademarks, software could theoretically fall under, well, it's almost always under trade secret, maybe copyrights, maybe patents. With copyrights and patents being like, is it worth it, right? Is the juice worth the squeeze? So quickly on trademarks. Trademarks are going to be important to your company from primarily a branding standpoint. A lot of startup companies end up getting some trademark either on the company and or the product or the service that they're developing. You know, you build brand value in that, and that's how you protect your brand is through trademarks. Could you patent software? Yes. Have we seen a lot of software that can fit into the type of thing that qualifies for a patent? No. It has to be like super unique. It's basically find a really good patent attorney with a computer engineering undergrad and talk to them about it. But for the most part, even for the things that could be patented or maybe even copyrighted, a lot of our software company clients they're not as concerned about the IP protection from a patenting or copywriting standpoint as they are about the confidentiality piece of it, because they know they're going to constantly be adding pieces of code, they're going to be constantly working on this, and it's going to be more dynamic, right? The design for a bicycle is pretty static. We can patent that. We did it. We have a bike. Let's patent it. Something for a software program, it's kind of hard to take a snapshot and say, boom, it's done. That's all I need. Go patent that, right? Or copyright it. So that's why those types of IP protection are not very common. Not to say that you shouldn't explore it, particularly if you're working on something super unique that you're not aware of that's out there in the marketplace. You should absolutely investigate it. Copyrights are expensive. Patents are effing expensive. The patent process can take 12 to 18 months just to get going. And again, you're working with the smartest attorneys out there, the patent attorneys, because they all have hard science or science undergrad degrees before their law degree. So again, when you're choosing a patent attorney, you want to make sure you find someone who has domain expertise in whatever it is that you're working on, ME, CE, whatever that may be.
What about for physical products, like how would that patent process look like? What would that look like?
Yeah, so generally speaking, the way the patent process works is you file a patent application, a provisional application, and that acts as your foot in the door. The date that you file becomes a very important date because you've told the patent office you think you have something. Then you start going through the review process with the USPTO. And so you spend a lot of money up front to get the provisional filed, and then you tend to spend money regularly for the next 12 or 18 months while you're handling comments and feedback from the USPTO. And then ultimately what you're looking for is for your patent to issue. And then once the patent issued, the way a patent works is it prohibits anyone else from practicing what's covered by your patent. It's good in each country in which you have a patent. So as I said, patents get expensive because once you've got it in the US, the next step is now we're going to go international. And we're going to pay to get patents in all these other places around the world.
I've heard some things about like some patents aren't even real, if that makes sense. Like some people, like they may file a patent, but they never build it.
Yeah, yeah. If you're not practicing the patent, it can be challenged and you can lose the patent. I think that may be what you're referring to. So yeah, patents are awesome, right? So where do we see patents most, just for context? We see patents most in things like medical devices, drug discovery, hard tech like displays and other things like that. Things that are kind of big bet type of things, companies. So, but there are a lot of hooks and requirements for patents, like practicing it and defending it as well. If you become aware that someone's infringing on your patent, you're required to give them notice. If they keep infringing, you're entitled to get 3x damages from them, which is nice. It's one of the nice things about patents. But it's not like you just get the patent and leave it, right? This is why trade secret becomes a very common thing for a lot of startup companies as IP protection. You create it, it's protected by trade secret. As long as you keep it confidential and everyone that touches it agrees it's confidential, you've got trade secret protection and you're not going to lose it.
Okay. Another question.
Yeah.
So patents are generally inventions, right?
Yeah.
Whereas, let's say you're innovating, right? And
Mhm.
you're improving an invention. Can
Derivative works?
Yeah. Can you do that? Let's say you have this idea of how to improve a certain system or certain
Yeah.
process. Could you still do that, or?
So derivative works are tricky. There's this concept in patent law of something being non-obvious, right? If the derivative is non-obvious, then it may be patentable. But, you know, I'm going to pass the buck a little bit here, but the professor you're working with, or maybe someone in tech transfer, are probably better, and sort of short of talking to an attorney about it, maybe try to chat with someone who's done a lot of patent stuff here at the university. Like I said, I know about this much because I watch it happen, but I've never actually done it. Yep. Yeah.
When kind of deciding the right allocation of equity for an advisor and kind of the typical agreement that you use for that,
Yeah.
how many typical advisors would you recommend? I know this is a very abstract question.
Yeah.
It depends on your industry and whatnot. But are there general rules that you see what equity that they put out?
I mean, I generally see really small equity awards to advisors, like sub 1%, maybe a quarter of a point or a half a point for a 1 to 2 year engagement where it's literally, like I said, if I message you, you're going to message me back. You're going to say good things about me in the marketplace. You're going to let me put your photo in your bio on our slide deck when we're pitching. Like, that's kind of what you're buying. So how many of those make sense? You know, it's probably more than one, but I rarely see like more than 10. It's usually a single digit number. And the other way that I would think about it if I were a CEO is domain expertise and what am I getting from each of these advisors? Well, I'm chatting with her because she's a multi-time CEO who's raised money. I'm chatting with him because he knows a lot about finance and strategy. I'm chatting with them because they know a lot about product development. You know, like, what's my sort of personal board of advisors? Because that's who generally interacts with these advisors, is the CEO. So what do I want for a personal, what am I strong in and where do I need help? That's how I would think about it.
Yeah, that's awesome. Thank you.
Yeah, no problem. All right, yeah.
As an early stage startup, how, in terms of prioritization,
Yeah.
how important is like having these advisors and these consultants and bringing them in? Like, how important is that?
So it's a really fair question. It may not be important depending upon where you're at, like in that early stage. So I do think when you go to raise money, when you go to raise real money and you haven't raised money before, having advisors surrounding your company are a great proxy for credibility, right? It's like, you may not know me, but these guys know me and you know them and they think I'm really good. So that can help a lot. Prior to that, with like the business advice and the guidance, I would suggest, kind of pick your head up and think about what's coming 3 to 6 months down the line in terms of the development of your company and where you may need some help. I'm going to need some product dev help, or I'm going to need some budgeting help, or what may be coming on your roadmap, if that's helpful.
When it comes to predicting that and
Yeah.
having like some type of clairvoyance looking into the future,
Sure.
how can you be less wrong in terms of like planning your future out?
That's y'all's question. That's an ops question. I don't, how do you de-risk your company?
Yeah, how do you?
Dude, execution risk is, I don't know that it's going to be hard, right? De-risking a company. So here's the way investors think about de-risking a company, right? They look at de-risking the market, they look at de-risking the team, and then they look at de-risking the IP or the secret sauce.
Can you elaborate on de-risking?
Yeah, so, what's our confidence level about this is a large and growing market? Okay, that's the market. On the IP, that part is, how special is this special sauce? Is it patented? Is it not patented? Do we see something like that out there? Is it easy to recreate? If Google decides they want to do this weekend, will they be up and running with a competitor on Monday? That type of thing. The de-risking of the team is one of the harder parts, because when you're an unknown quantity from an investor standpoint, it's just trickier. For you to de-risk things from where you're standing going forward, I would suggest that you think about what it is you're aiming for. What are your milestones? And what do you need to do to get from here to there? Because when you're out chatting with investors, one of the things that they want to know is that you're following through on doing the things that you say you're going to do. We plan to have revenue in Q3, or we plan to have an MVP in Q1, or whatever it is you're saying you're going to do. Those are the types of things that become important in terms of building credibility. Okay? Well, these guys had their hands up. Let me come back. It's all right.
Going back to bringing in investors and stuff, in the event of a liquidation of the company, how do you determine who gets funds first? If that makes sense.
Yeah. Generally speaking, people that write checks get money back first. All right? So the idea of a liquidation preference, which virtually every venture-backed company has, says the investors who will be issued preferred stock, your founder stock will be common stock. One of the ways in which their stock is preferred is they get money back first. So if I've invested $1 million, I get the first $1 million back. Now, there is this next level concept of, do I get my $1 million back and then my ownership percentage of what's left? That's what's known as participating preferred. Or do I just get the greater of my $1 million or my ownership percentage multiplied by the total? That's a non-participating preferred. The founders prefer non-participating preferred, right? So they don't double dip. They get the greater of. That's what you want, is the greater of concept. But that's a negotiated term in a term sheet.
So then, I guess, with multiple investors,
Mm-hmm.
and then how do you negotiate?
They get stacked. So when you start to raise money, your first round of financing will be Series A, well, usually Series C, but for purposes of this example, Series A, and then Series B, and then Series C, and then you exit. The investors negotiate amongst themselves the priority. Does the Series C get paid first, then the B, then the A? Or do they all get paid together at one time from the proceeds? Pari passu or in order? Yeah. So that's not as much your concern as a common holder, because it's all going to get repaid before you. It's just what order does it happen?
And you're saying that they'll negotiate that between themselves?
They'll negotiate, like Series A, when Series B comes in, Series B will say, we want our money back first, Series A, and you'll be second, and then common will be third. And depending upon how hot your startup is and the relative leverage, Series A may say, we don't like that. We want it all to be pari passu. So, yeah.
What scenarios do you see pari passu? Like, what, for the Series C round investors, what's the advantage to them in that situation?
There's no advantage.
Yeah.
No. But keep in mind, except in cases of participating preferred, but let's just assume everyone's going to get the greater of, which is more standard in like really great high growth companies. This liquidation preference only matters in a downside scenario, right? If I invest in your company and I buy 10% of it for $1 million, I don't want my $1 million back. I want 10 mil, right? I want my 10% to be 10% of a $100 million exit. So I don't want the liquidation preference, but I need to have it for protection. So yeah, they negotiate. So yeah, how does that go? It's like every round, like what's the strength of the company? What's the market like? Those types of things.
I guess even for the downside protection, like
Hmm?
why would a Series C or D investor even like do that rather than just taking the highest of the stack and then.
Yeah, so they can get into the deal, right?
Okay.
So you're a Series C investor, but so is he and so is she, and I'm like, well, I'm going to pick one of you. Which one's giving me the best terms?
Gotcha.
Yeah, that's the kind of market you guys want as founders, right? Is you want founder-friendly markets. Yeah.
Do you work with 409A evaluations at all?
We don't do them, but we do use them for our companies. Yeah.
So kind of when you're pre-revenue and 409A is kind of, you know, a little bit less relevant, how do you kind of pick a fair valuation? And is that your field or do you know?
I know what you're talking about. It's not something that we do, but we guide boards. So generally speaking, you know, the ideal, right, the safe harbor under the Internal Revenue Code is you go and hire a third party to generate a report to tell you what you already know, which is that your common stock is wicked cheap. But at least they've done it, and now you can rely on it. The next step down from that, according to the IRS guidelines, is to go and find someone with 10 years of finance experience who generates their own version of the report, gives it to the board, and then the board says, we're going to use this. Below that is the board doing its own work with management. And then the worst case at all, what you don't want to do is say, well, this is the price we use for our founder shares. Let's just keep using that. Like the no analysis approach is the worst. Yeah, no problem. There's risk in all of those though, below like that third party that you pay for. The risk increases as you get down to like just being lazy, you know. All right, did you have one? Are you good? You're good?
Oh, yeah, so I just had a theoretical question.
Sure.
I don't know if you have the answer for this, but it's about trade secrets
Yeah.
and patents or copyrights.
Mm-hmm.
So if a company has a trade secret and it's written in history that they are the first ones to have done this,
Mm-hmm.
and somebody comes out and they make the same product basically and they copyright it or patent it, what's like the battle there?
Prior art.
It's what?
Prior art.
Prior art?
That's the term. So if you Google prior art in connection with patents, if you have prior art that precedes the filing of a patent, then you're allowed to practice your prior art.
Okay, gotcha.
Yeah.
Cool, thank you.
Yep, no problem. I know more than I thought actually on patents, I guess, but go ahead.
So I'm a digital, right?
Yep.
And a lot of this business stuff is like, what is it called?
Yeah,
Like, I
you
don't know.
need you need a Warrington co-founder. Yeah.
But what would you recommend I do in terms of like not just bringing someone on who like has the whole business thing, but learning myself so I can better understand what they should be doing and what they should not be doing.
Oof. You're talking about like resources and stuff like that?
Yeah, like resources, anything I can get my hands on, read, watch, something.
I'll tell you what. So I know you guys have seen it, but I'll reshare with these guys our founder's handbook, and we'll just publish it to the class if that's cool.
Yeah.
You guys take a look at the founder's handbook. It covers everything that we've covered plus a lot more, and then there's a index at the back with like what we read and what our clients are reading. Take a look, and then if you have any other questions, give me a call. I'm always happy to chat. Yeah.
I'll call you.
Sure. No, these guys know, like, I love doing that. I've been doing this a long time, so I love doing it. I want to be respectful of everyone's time, though. We're at 12 after 7, 7:15. Should we do a few more Q&A, or?
As long as you're good on time.
I'm good. I can hang out for a couple more minutes. Were there any more questions, or? Yeah.
So the question about the regulations.
Oh.
Kind of like data and storage.
Yeah.
The way our systems work is it'll take patient data
Okay.
from the dental office
Yep.
directly from the patient.
Yep.
But it's just their name, whether they have insurance or not. It's nothing like related exactly to their insurance provider or their social security number.
Mm-hmm.
Just their first and last name, some contact information.
Yep.
We don't store any of it on our own data systems. It's all goes right through to a sheet that the dental office has
Yeah.
access to. So we can't really see the exact patient information from the dental office.
Yeah. Yeah. So you're asking whether you might be regulated by HIPAA?
Yeah.
Yeah, you may not be, but my guidance to you, and I'm not a HIPAA attorney either. I'm not a lot of things, as it turns out. I'm just a really good corporate and transactional attorney. But my guidance to you, based on what I've seen in practice with this, is you may have great arguments as to why you're not regulated by HIPAA, but insurance companies and dental offices and other parties that you're interacting with, they may not care and may not want to take the risk, and they may require you to sign up these BAA agreements, which is how stuff gets done under HIPAA, business associate agreements. And so just be prepared. If you have to do it, it's not the end of the world. It's just once you start doing it, you need to do it for every data source and every doctor's office and all of that. Yeah, we've seen a number of companies that have like played in that type of space. And one of them, like they weren't touching anything potentially sensitive, but they were simply selling to insurance companies. And so the insurance companies are like, yeah, that's great. We'll write $1 million check and give you the revenue, but you're now going to treat yourself as if you're HIPAA compliant, because we're not going to take the risk of you doing something that we can't control, right? Because you could flip the switch tomorrow and start getting different data, and they would have no control over that. So they're just going to want the BAA in place anyway.
So start doing it now.
I think so. I mean, there's no downside to not doing it now. I would say the downside would be if you got really adamant and it doesn't sound like, hell no, we don't need this, we're not that, just be ready for it. But I also don't know that I would go ahead and say you have to start being the one to suggest it. I would expect the other side will be the one suggesting it to you or requiring it.
Okay, so any officers you talk to haven't requested it yet, should wait until one does? Okay.
Yeah. Again, as long as you're only taking the data and holding what you talked about there, right? But not surprisingly, a lot of companies, they start like this with data and then they realize it's awesome. And then they start to go like this with data because it's even more awesome. So in that case, you may end up working backwards if your data plans, if your use of data and what you're going to be transacting in changes, then you may have to go back. So maybe I'll amend what I said before. If there's a chance you're going to get broader, yeah, go ahead and get the BAA in place. That way you can go grab all that stuff if you want it. Yeah, no problem. Yeah.
I want to jump back to founders agreement, operating agreements.
Yeah.
What have you seen as best practices of companies that revisit their contracts? Is it common for them to do that? And
Yep.
How far out do they go to state to revisit it?
Sure. And when you're talking about revisiting their contracts, are you talking about their founder vesting or the governance and things like that?
Correct. Like let's just say life changes and then
Yeah.
someone eventually plans to maybe leave the company and,
Yep.
and just say, hey, we'll revisit this contract next year so you get less.
Yep.
And then
Yeah, so that does happen, right? We see founder agreements, founder vesting agreements amended, changed. Not all the time, but we see it happen. We also see founders who run the full 4 years on their initial, and then they negotiate for another slice of equity in the company to keep them tied for another period of time, what's known as a re-up of equity for the founders. So we see that as well. Generally speaking, the governance documents of the company are not going to change that often, except in connection with big corporate events. And for companies like yours, that's generally a financing transaction. So when we raise that Series A financing, we're going to negotiate with the investors on what the charter and bylaws say and what are the rights of the preferred stock. And we're going to sort of put all of those terms together. And the Founders Handbook goes over some of this. But then when we do that at Series A, we're going to live with those until we get to Series B. And then we'll revisit them at that time. So, it wouldn't be unusual. We'll do it now on the governance when we form it. We'll revisit it at Series A. We'll revisit it at Series B. But as counsel, I would start to get a little nervous if we were reopening governance documents regularly. Like, what's going on with this team, right? They seem a little too concerned about governance, maybe not as concerned on actually building the company. Yeah. This was great. Thanks so much for your time. You guys asked some good questions. As I said, feel free to follow up. If you're going to ping me on email or something, just remind me it was from tonight, and I'll be happy to chat with you. But good luck with your startups, guys.
Thank you.
No problem.